Hello and welcome to Legalese. My name is Vincent Perryman. I'm a local attorney with the law offices of J. Vincent Perryman. Each month, Legalese focuses on a wide range of legal issues and topics. Today's show covers trust law. With us is attorney Angela Lawson of the law offices of J. Vincent Perryman. Angela, thanks for being with us today. You and I do a lot of estate planning for our clients and things like this, and one of the topics that we always have to cover is trust law. And we run into the thing of a lot of people, they've heard of trust, they think of it as something that the Kennedys or the Rockefellers have these, or a trust fund baby or something of that nature. But realistically what it is it's an estate planning tool which has always been very valuable in using for different purposes and things like that. And really with their, all trust, as there's a huge variety of them, they break down into two separate categories: revocable trust and irrevocable trust. If you would, explain to us what each one of those are.
Well, like you said, there's revocable trust and irrevocable trust. The revocable ones are just that. You can undo them once that you set them up. A lot of those times those are used for when you're creating wills. A lot of times you'll create a living trust, which is also a revocable trust. The irrevocable trust is just that. You can't undo it. Once you give the gift to the trust, it can't be undone. It's gone. And there's many different types of irrevocable trusts that we'll probably talk about in a little bit.
Okay, now with the revocable trust and the irrevocable trust, there are some common elements to these trusts. What are those?
Well, all trusts have four parts. They have a settlor or a grantor, and that's the person that has the assets that they want to put into a trust. Then you have the beneficiary, and the beneficiary is who is going to get the benefit of the things that are put into the trust. And then you have a trustee. The trustee is the person is picked by the grantor, the settlor, and they are going to manage all of the assets in the trust. So they're going to make distributions of the property to the beneficiaries. They're going to help manage the assets to make sure they're not wasted, invest the assets of the trust. And they're governed by a set of rules which are either in the trust document, which is the fourth part, or by state law. And the trust document is where you list out all of the powers of the trust. It gives all the duties of the trustee and says what can and can't be done with the assets that are in the trust. It's kind of like a constitution that governs this trust.
Okay. Now, with the as far as when we're looking at these different trusts and everything on this, with this, I guess if I'm sitting at home watching two of us talk about this, I'm wondering, well, why would I need a trust unless I just have massive amounts of wealth to give? On that, what are some of the considerations that you might look at as to why someone might create a trust?
Well, trusts have a lot of benefits. Let's talk about the revocable trusts first. Those are the ones that you can use to help with your estate planning. They are private. They don't usually go through probate, which a regular will would go through probate. They are, the trustee is able to help facilitate the trust without having to go to court. In a regular will, you would have to go to court. But you can explain, sometimes in a will, won't you find a trust?
Well, yeah, and that is true. Sometimes with the estate planning, I guess, if we back up from this and we break it into talking about just the revocable stuff, the choice comes there, the client comes to the door, and we kind of give them the option of, do you want a will or do you want a revocable trust, which realistically would aid you in avoiding going through probate and having a judge make a decision. But both of these documents can also have irrevocable trusts that are triggered and created at the time of the decedent's death. when they pass away, and that gives you some flexibility and some things like that in there. So I think with this, one question is when somebody comes through the door, we have to explain, well, there's two varieties of trust, because we see that a lot of times where we have someone that comes through and they say, well, I want a trust. And, we look at them and say, well, what sort of trust do you want? And they don't always know. So it's the whole thing of educating on that. Most times people are thinking, if they've talked to a financial planner or something like that, and they have, a reasonable amount of assets, not some huge taxable estate or anything, then with that, they might be interested in keeping it private, keeping it out of the public eye, because if you do go through probate, you well know this, that if anybody wanted to see Elvis Presley's will, they could go down to the Shelby County probate, pay a little bit of money, and get a copy of it.
Yeah, wills are public documents. They are, if you have just a standard will, you have to go through the court to get your assets distributed. You have a personal representative or an executor that works kind of like the trustee would, but it still is guided by the rules of the court. And everything's public. Any inventories that have to be filed are public as well. So the trust helps keep things a little more private.
And I think the other thing that we always have to explain to people with a trust, and this is the confusing thing with the revocable trust, is that so long as you're alive, the settlor or grantor, who is you, say it's my trust, I create this trust, I'm also serving as the trustee until my death. Then a successor trustee steps in and my trust becomes its own entity, whereas as long as I'm alive with a revocable trust, really that grantor and the trust are all just the same entity. Now, the thing, the question that we've seen is, well, why does it cost more to do a trust instead of a will? And I think that gets to the whole thing that a proper trust has to retitle several things. And you can speak, you've had to do some of this, you can speak to what has to be retitled.
Yeah, if you want to create a trust, you're creating an entity, like a being that is going to be the owner of all of these assets. So you have to retitle, if you want your house to be part of the trust, you have to retitle your house and so that it's in the name of the trust. If you want your car to be part of the trust, you have to retitle your car. There's a lot of transfer documents that have to be executed when you have a trust in order for your trust to be funded.
And what I think is interesting is you'll see a lot of people that they'll get a nice leather binder and everything looks really nice and they've got this nicely drafted trust. But then you start looking at all their assets and whoever created this didn't transfer it into them, so now they have an unfunded trust that really is doing them no good. So it's important, I think, to make sure that you've got somebody that's going to follow all the steps, work with all of your financial advisors, your CPAs, whoever's managing your assets, if you've got a stock portfolio, things like that, to ease this transition, to say, okay, this is what we need to do to get this done. Because otherwise, then we're relying on the other document that we do with the revocable trust, which is a pour-over will, which pours everything. We go down to probate and say, Judge, we forgot to fund it. We need everything poured back into the trust. So then the trust operates that way, but we wind up in the same trouble of it's now public again. So when we return, we'll continue our discussion about trust law. Please stay with us.